Hello?
I can hear you, Judge Shapiro. It looks like we are still waiting for an attorney for the plaintiff.
All right, and right now I'm looking at it and it's in a tiny little box. How do I make this full screen? I may have done something wrong. Thank you. And how do I make it so it's a grid? View.
If you select in the upper right, if you select gallery, it should give you the ability to see all the screens at once.
I do have it now. Thanks.
Good morning, Judge Shapiro. I just want to let you know that it looks like we have attorneys for both sides as well as the court reporter ready whenever you are.
I'm ready.
Good morning, Judge Shapiro. I'm Cindy Chyla, the court reporter.
Charlotte, nice to meet you. Mr. Fowler.
Good morning.
Morning.
Okay, so before we go on the record, Mr. Kelly, can I ask, are you here for the plaintiff?
I am here for the plaintiff.
Okay. Just give me a minute here. I'm sorry, excuse me.
Before we go on the record, gentlemen, what do you think about doing these motions by Zoom instead of live?
Oh.
I love them, Your Honor. I think it's great.
Okay. I think it's great for the lawyers. It's a little less advantage for me, but that's okay. It's not that much, really.
And just the waste to the client's money and the time and how much more we can do with it, with cutting out the driving. I think it's wonderful.
Good to know.
All right, thank you. I appreciate it.
All righty, so I'm going to call the case. It is Court of Claims case number 2175 MM T&V Associates Inc. doing business as Rivercrest Catering versus Elizabeth Hertel in her official capacity as Director of Michigan DHHS. This is the defendant's motion. So Mr. Fowler, if you'd put your appearance on the record and feel free to start.
Thank you, Judge. Assistant Attorney General Darren Fowler on behalf of the defendant, the Department of Health and Human Services and its Director, Elizabeth Hertel. Judge, I'll be very brief and then happy to answer any questions you may have. This is a declaratory judgment action. Declaratory judgments are a form of relief that are available to resolve actual controversies between parties, to define their relationship and their conduct toward each other going forward in the future. Declaratory judgments are not available to resolve hypothetical issues on contingent events or upon speculation. Unfortunately, that is all that the plaintiff has brought to this court in this declaratory judgment.
Isn't it possible that this will recur? I mean, that seems to me that that's their response to the mootness argument.
Well, I think the question then is possible what will recur, Judge? I mean, is it possible that there will be another pandemic? We can certainly speculate there might be. Is there a possibility that there will be a potential variant that will be so deadly that that some type of restrictions need to be put into place? That's conjecture. We don't know. And those are the kinds of conjecture and speculations that declaratory judgment case law says are not proper. And even if there were another variant or another pandemic in the future, this plaintiff is still challenging very specific mitigation responses that were put in place. Those of a year ago to restrict indoor dining at 50% and the closure time at 10 o'clock, and then it was modified to 11 o'clock p.m. So here we have multiple layers of speculation and contingencies. Will there be another deadly variant that warrants mitigation, or will there be another pandemic in the future that warrants mitigation? And if there is, on top of that, would this particular measure of 50% indoor dining be brought to bear on that situation? And would, again, a closing time of 11 p.m. be brought to bear? So that's a lot of layers of contingencies and speculation.
Okay.
Add on top of that, in this case, the other important fact is that Rivercrest Catering, this banquet hall, closed its doors December 31st, 2021. It was a food service establishment, but in their reply brief, they acknowledged they're closed. Their social media says they're permanently closed. So when we talk about what kind of relief is appropriate, a declaratory judgment defining the relationship between the parties going forward, there's nothing that Rivercrest can achieve in a declaratory judgment that does that. It's not going to be providing indoor dining in the future at any capacity. So debating whether a restriction that existed over 10 months ago about 50% capacity is a hypothetical issue in the context of this case.
Can you speak to standing?
Standing, almost like the other side of the coin on the mootness argument here, the League of Women Voters decision from the Michigan Supreme Court was emphatic that a party needs to show standing throughout the litigation. Significantly, in its reply brief, Rivercrest tries to point this court to the McNeil decision by the Court of Appeals that invokes the relation back doctrine, that a complaint is deemed, that standing is determined at the time a complaint is filed. But the McNeil case was a case seeking retroactive relief, seeking money damages in the context of a medical malpractice action. That's not the case that Rivercrest brings to this court. This is a case where it seeks only a declaratory judgment declaring the prospective, the rights of the parties going forward. So that case, McNeil, is inapplicable. League of Women Voters controls on question of standing, and the plaintiff here doesn't have it because it doesn't operate any longer.
Okay, if you want to stop there and we come back to you to talk about the constitutionality, assuming Mr. Kelly spends time on that, okay?
Fair enough. Thank you, Judge.
Sure, Mr. Kelly, your appearance, and then you can begin your argument.
Good morning, Your Honor. Sean Kelly on behalf of the plaintiff, T&V Associates. I think I will run through basically everything we have in our complaint. I want to point out a few things just as a threshold matter. This is obviously a renewed motion for summary disposition. In our first response to the defendant's summary disposition motion last year, the plaintiff proffered a statistical model comparison between pneumonia and COVID-19, which proved that COVID and pneumonia shared nearly identical death rates. Last, we were before this court in front of Judge Stevens on oral argument. Defendant, through counsel, argued that the plaintiff's pneumonia and COVID statistical comparison was unfounded and inaccurate because the data used by plaintiff at that time was from 2020. The argument, according to the defendant, was that COVID was only present in Michigan for approximately 9 months in 2000.
Let me stop you there before you go further, and you can argue as much as you want. I'm not shutting you down. Which is all of these factual disputes. What have they got to do with the legal issues? I mean, your legal issues are well crafted, but I'm not sure what difference the facts make.
It's specifically because it's continuously argued that by the defendant that the implication of and the use of this public health law, specifically the subsection at issue 333.2253, was predicated upon the fact that this was, quote, and this is from page 20 of the defendant's brief in support of the summary disposition motion, was among the deadliest in all of the nation's history. And that's simply not the case, Your Honor. So we're arguing both as applied and facially the unconstitutionality of this statute. And of course, we're arguing against the director's orders, specifically because she's using it in an arbitrary and capricious manner. If you're going to do it for COVID, why not for pneumonia and vice versa? So, I mean, again, the defendant's argument was that plaintiff's data was skewed because we were using data from 2020 and COVID had only been around for part of 2020. and pneumonia is a disease that circulates throughout the year. Thus, the argument continued the plaintiff's data was off. Time, of course, has proven the defendant wrong on this issue. And the same is true with virtually every other so-called scientific issue surrounding COVID-19, as argued by the defendant. It's a C8 motion. They're bringing in a ton of facts in here, talking about this and that with the scientific data and everything. It's a C8 motion. We're not supposed to be wading into the facts.
I agree. I'm not terribly concerned about the facts. You're welcome to argue them as you like. Both of you briefed the facts extensively, probably as a defensive measure, but seems to me these are pretty straightforward issues of the constitutionality of the statute and whether they're standing and whether it's moot. So anyway, with that, go ahead and continue, Mr. Kelly. I'm sorry.
Not at all, Your Honor. And so I wanted to point that out, that, it's not surprising to plaintiff and all those who have consistently posed the government's draconian regulations regarding COVID, that it turns out across the entire year of 2021, the COVID death rate was exactly the same or largely equivalent to month by month the death rate in 2020. And more importantly, that the pneumonia death rate was statistically identical to the COVID death rate in 2021. This data comes straight from the state of Michigan and definitively proves the defendant was completely wrong last year when she argued the mortality rate comparison proffered by plaintiff was skewed. Again, this comes as no surprise to those across the state and my client who have long shouted that freedom should be the baseline, the backdrop, the default, if you will, position, rather than jumping to these sort of drastic, relentless, authoritarian, and repressive rules based on arbitrary science that continue to be proven wrong time and time again. I understand that the other side is going to argue that this is a position and an analysis with the benefit of hindsight. As I said, I don't think that's the case. My client has said from the very beginning, as have individuals and business organizations throughout the state of Michigan alike, that freedom must come first, and science, which is so imperfect and changing, and which is extremely arbitrary when it's in its infancy with something so new like COVID, should not and cannot be the impetus for rules that take away people's fundamental rights. This is especially true.
I'm listening because really, I'm only interested in whether or not the statute is okay. I don't see in your request for relief or elsewhere in your brief, and I may have missed it, so feel free to correct me, that you're asking for a ruling on whether or not the department's actions were correct or not. I only see to determine whether or not they were lawful or not. Have I missed that?
No, in our prayer for relief, it's requesting the whether or not the director's orders and or the statute itself, 333.2253, are constitutional, both facially and as applied. Okay. And so you get that, it's kind of a mix where everything's in there. And so the arbitrary and capriciousness comes in with what science was the director relying on when she issued her orders? Was she aware that the science is ever changing and therefore the basis of orders, which the foundation of which is predicated upon science, which is ever changing and has changed throughout the pandemic, could it ever not be arbitrary to take away people's real estate when we don't even know what we're doing? That's the concern here, Your Honor. And the counter argument has always been from the defendant that these courts should be giving the government the benefit of the doubt on COVID. That's the legal argument. I think that appears to be somewhat of a foregone conclusion argument. Like, it's sort of the shades of the Wizard of Oz. Nothing to see here. Don't look behind the curtain. Because if you look too closely at the science, or more importantly, the results-based data, it shows that lockdowns did virtually nothing. We cite a study in our brief.
I got all that. Really, I mean, I understand that you're asking me also for a ruling on whether or not the specific action was arbitrary and capricious, and that's covered very well in your brief in terms of the facts. I'm more interested really in 2253.
Okay. I think that that's really the important crux of 2253 is that the non-delegation doctrine is obviously extremely important to Michiganders and at the federal level as well, regardless of what constitution you're talking about. It's designed so that people are not unprotected from the checks and balances upon which our democracy is based, from this sort of uncontrolled arbitrary power in the hands of administrative officials. That's a direct quote. Department of Natural Resources versus Seaman. It's a 1976 Michigan Supreme Court case. And I don't see how you can't get a better picture of that happening than this instance. You have an administrative official, a department head, issuing orders basically with no control whatsoever. I mean, the way that the legislature unbridled the power of the executive branch to an unelected bureaucrat of the executive branch through 2253 is capacious.
Let me ask you a question. Let's say the director issues a ruling that the legislature thinks was an error. Couldn't they pass a statute at that point and address the problem? They certainly seem to, in this statute, have wanted to give pretty omnibus authority. And your suggestion is it's improper delegation because it's omnibus, but the legislature's hands are not tied.
Well, the legislature can always go back and change the law, but prior to doing that, the reality is we have to look at whether or not the law in the first place as drafted by the legislature was itself constitutional. And so when we look to the language of 2253 itself, where it says the public health director can prohibit gatherings for any purpose,
right?
And that emergency procedures shall not be limited to this code, that appears to make the transfer of power from the legislature extremely broad, to the point where it's self-defeating language, where the language is not limiting the defendant's power to the public health code itself.
Would you agree that 2253, I recognize the constitutional issues, 2253 does not suffer from the statutory problems that 304 did with the 28-day limit and not providing specifically for epidemics?
I will concede that point, except to the extent that whether or not we made this argument in our brief as well. And of course, defendant first brought the argument to bar that it needs to be, these laws need to be narrowly tailored in such a way that they're sufficiently specific to one area, but it's not necessarily, as we counter argued, it's not necessary that it be just narrowly tailored, but that it doesn't delegate too much power to that which it is narrowly tailored to. Meaning that, yes, okay, it's not giving the public health director carte blanche to do whatever she wants, whenever she wants, however she wants. But with respect to epidemics themselves, she's been given the power delegated has been too broad when it says the power is not even limited to the code.
Why would you put the limits on the power, since obviously someone has to respond to an emergency pandemic if there is one, and whether or not we have time for legislative hearings and debate and maybe stalemate, suggests that there does need to be some executive authority. So where would you draw the line, if anywhere?
Well, and there certainly does need to be executive authority, of course, but whether or not the legislature is nimble or quick enough to be able to restrict power accordingly and constitutionally when they in fact do not delegate power constitutionally, that I'm not aware that that's in any part of any analysis. They have a duty in the first right to delegate the authority constitutionally through the statute. And so, I mean, where would I draw the line? I would certainly not have in the law that the director's powers shall not even be limited by the public health code, empowering the director with any sort of public health powers.
Okay, I get that. So I cut you off a couple of times, so I'm going to shut up now. And if there's more you want to say, feel free.
Not at all, Your Honor. I appreciate it. I think, I'll cut to the chase and just talk very shortly about a few of the things that Assistant Attorney General Fowler discussed.
And I'm concerned about standing, so do mention that at some point.
Absolutely, yeah. Really the mootness and the standing issues here. So I'll address each in turn then. As far as mootness, there's a case cited by defendant for the proposition that this matter is moot. It's Contesti versus Attorney General, a 1987 Michigan Court of Appeals case. And in fact, that case does not inure to the benefit of the defendant. That the court there found the matter in question before it justiciable. And defendant claims in their reply brief that the plaintiff made no effort to sort of overcome anything that occurred as a result of the order's rescission with respect to mootness. I think that nothing could be further from the truth. We cited Hernandez, which comes from a long line of jurisprudence allowing a review of technically moot cases when constitutional issues are afoot. And we further pointed out the logical impossibility of defendant's argument, which is simple. It was the defendant's actions that forced my client out of business. Defendant's argument that plaintiffs should be denied the equitable relief of having a statute declared unconstitutional when such statute was the reason it is no longer in business, it's truly scary. Any decision that holds in that manner would make it so that the state could force an individual out of business in order to avoid a constitutional challenge against the very statute used to force a person out of business. And so as far as mootness goes, I think that that's a very important point to make, right? The government can just use the law to essentially bludgeon someone into a hole and then say, nothing to see here, no problem. You can't attack us now any longer. I think that this sort of segues nicely into plaintiff's standing argument as well. Let me back up first. The standing is a limited prudential doctrine, first and foremost. And a litigant has standing whenever there's a legal cause of action. My client has several causes of action here and has pleaded those causes of action. This is a C8 motion. My client's allegations must be taken as true. Full stop.
Mr. Kelly, your client is not seeking money damages, am I right? Just a deck action?
That's correct. But
okay.
Even when the cause of action is not a quote unquote legal cause of action, but rather an equitable, a party can still have standing if the party has a special right or injury or a substantial interest that will detrimentally be affected in a manner different from the citizenry at large. I think it's patently obvious that my client has a substantial interest that is detrimentally affected in a manner different than the citizenry at large, not food service establishments, not restaurants, from the citizenry at large. As my client was one, a food service establishment, two, was open after certain hours, and three, was open to indoor dining. Three of the things specifically restricted in Director Hertel's orders. My client's not an industrial factory or a school or an individual who can work from home making quilts or a veterinarian.
But you would agree that any of those places that had to be closed, whoever is the manager or owner would have standing.
With those,
they were tested by the order.
I'm sorry, say that again, Your Honor.
Would you agree that all of the other places that had to close, as you just went through, the owner or appropriate representative would also have standing, just as you say your client does?
Absolutely.
Okay, I'm just checking.
Which again means that my client does have standing, but the standing of other litigants does not necessarily hinder my client's ability to have standing in any event. We're also challenging the law as facially unconstitutional, which appears to at least confer standing on my client. Again, we're talking about constitutional issues of import. It appears if it's facial, my client need not show a particular injury or right damage, merely that the statute is unconstitutional under any circumstance. As I mentioned before, how could 2253 be constitutional as it delegates by its own terms more power than the legislature necessarily could even delegate outside the public health code that created the position of the public health director?
Mm-hmm.
I think on due process issues, which were mentioned briefly, the defendant never actually argues that it denied my client due process directly. There is certainly an interesting legal argument made the generally applicable standard exception to due process, procedural due process. My client, our argument is that it does not apply here because, again, the generally applicable standard exception was not to all businesses. It was not applied across all businesses. It wasn't, again, even applied to all food service businesses, Your Honor. There are food service businesses that were not open after 9 p.m. There were food service businesses, plenty of them, that do not have indoor dining. And so we get into the situation where we talk about adjudicative versus legislative and whether or not due process is implicated when it's only legislative and not adjudicative. How granular do we need to get? At what point does it change from a legislative character to an adjudicative character implicating due process? Would it be sufficient to say that it's adjudicative in nature when the government issues an order saying that all blue buildings on Washington Street in Richmond City cannot be open after 5 p.m.? That certainly appears to be adjudicative. And so we see that here where, particularly with respect to the orders, there was a serious level of analysis being done directly on food service establishments with particular criteria that's extremely precise, right? Where they open a certain amount of time, this, that, and the other thing. And so it's a fine line. And obviously I have to let the court decide whether or not it's legislative versus adjudicative, but it appears to us to be more adjudicative with a legislative character as pretext.
Okay. Anything else?
I'm available for any questions you might have, Your Honor.
I've asked you plenty. Mr. Fowler, do you want to respond to any of that?
Very briefly, Judge, the notion that the legislature doesn't know how to follow the Constitution really is kind of the premise of plaintiff's non-delegation argument there. The legislature knows well its constitutional obligations and how to follow them. In Article 4, Section 51 of the Constitution, the people of Michigan told the legislature that the public health is the matter of primary public concern, and the people told the legislature enact laws to protect us. Epidemics are the greatest public health threat to people in this state. They have been for centuries, and it's still true today. So the legislature, in crafting Section 2253, sought specifically to create an epidemic response statute, a method to protect the people and preserve their lives against a deadly threat. That is what the legislature intended to do. It did so constitutionally and deliberately, and it did so with safeguards both within that statute and within the public health code broadly, to ensure that that would be done in an appropriate way. Among those safeguards is the person entrusted with that power. As counsel acknowledged, it's the head, the director of the department. We are talking about somebody who is a gubernatorial appointee. The safeguards that exist there are the same as identified in Westervelt, the case we cite in our brief. You've got a person appointed by the governor, elected by the people, who every 4 years comes up for re-election and the people assess. Now, some people agree with what a governor does, some people disagree, but the effort by the legislature, by the director, by everyone involved throughout this pandemic has been to protect the lives of Michiganders against a virus that in this week is reaching a point of having taken the lives of more than 1 million Americans in our country in just over 2 years. It's a serious threat. The department has tried to put forward science to offset arguments that confuse people about science, such as were offered here today. Obviously, this court doesn't litigate science, it litigates law. The department followed the law. The legislature followed the Constitution in enacting that law. This case, though, ultimately is moot, and this plaintiff has no standing. Mr. Kelly tried to make it seem that there is something sinister that happened here because Rivercrest is no longer in business, and he blames the department for that. Mr. Kelly, though, was also very clear that this court should be looking at the complaint and not fact argument. The complaint doesn't include the allegations that Mr. Kelly argued there in that regard. In fact, the complaint didn't disclose at all that Rivercrest was closed, even though that amended complaint was filed after the closure. That was something that is available on social media that this court can take judicial notice of. So we don't know, other than Mr. Kelly's representations today, what went on at Rivercrest, why it decided to close its doors apparently 6 months after the dining restrictions it seeks to challenge here today, what impact they had. We don't know. We do know this pandemic has been very hard on people throughout this state. It's been hard on food establishments. It's been hard on all kinds of businesses. It's been hard on all kinds of people, people who have lost loved ones. Everyone has felt the impact. No one wants to, we're not questioning that the pandemic has caused hardship for anyone. It has caused hardship for everyone. But the case here, Judge, ultimately, at the end of the day, is one being brought seeking prospective relief in the form of a declaratory judgment. There is no broad exception like Rivercrest tries to carve out or point to in its argument. In its brief, it looked to the Michigan Court of Appeals case, Michigan Alliance of Retired Americans, trying to say, hey, look, if we're alleging a constitutional violation of public significance, you can ignore standing, you can ignore mootness. That representation is not accurate, Judge. In that case, the Michigan Court of Appeals looked at MARA, that Michigan Alliance of Retired Americans, and said, this entity alleges in its complaint, it has over 200,000 members. Its members are elderly and disabled citizens who seek to vote. There is an assumption we will make that they have the kind of injury in upcoming elections that gives rise to standing. So the court was making an assumption of an injury to get to the legal issue. Here, there is no assumption that can be made where the restaurant seeking to bring the claim is closed, where the order that the restaurant is seeking to challenge is one that ended more than 10 months ago, where any notion of restrictions and any notion of their application is conjecture and hypothetical. This is not like an election where we know every 2 years there's going to be local elections, every 4 years statewide elections. Elections, I kind of define a lot of the case law plaintiff is pointing to because they keep happening. This is something very different that we are dealing with, and this plaintiff has no standing to bring the claims that are moot to this court. Thank you.
I have a couple of just practical questions. Do either of you know whether the case that the Supreme Court denied bypass on where does that stand in the Court of Appeals?
Judge, I believe you're asking about the Iron Pig case, and that is still on application pending before the Court of Appeals.
Oh, that was on an app. It wasn't a claim. Interesting.
Correct, because it was an appeal from an administrative decision in circuit court that goes up to the Court of Appeals on application. So now that the Supreme Court has denied the bypass application, we are awaiting to hear from the Court of Appeals on the application to that court.
All right. Also on a practical matter, in the event that this motion is denied, it looks like we don't have a scheduling order. I don't know if a trial is needed in this case or if what we're doing today is going to, is the essence of it. Can I get your thoughts on that?
Judge, because this plaintiff has no standing and it's a moot case, it's hard to envision what a case would look like, what discovery would look like. Certainly, we'd welcome a dialogue if this court denies the motion, but I can anticipate that we would appeal were that to be the case.
Well, my suggestion is that you think about it, because if I deny the motion, I'll issue an order for a very prompt scheduling conference, and we'll get that done. Okay.
Understood, Judge, and we appreciate that heads up.
Mr. Kelly, you want to say anything about that issue?
If I may, very briefly, Your Honor, I know I've been rather loquacious today, and I apologize. I'll try to speed through real quick, but just a few counterpoints. So, Mr. Fowler pointed out, and he made sort of quite a few factual and legal conclusions here. One, that the legislature knows well how to follow the Constitution. We saw that less than 2 years ago, the Emergency Powers of the Governor's Act was ruled unconstitutional in full. I don't know that the proposition that the legislature knows full well how to enact laws that are constitutional is a sound argument, particularly in such close temporal proximity to an entire law being rendered unconstitutional. Again, we're only asking here today that 2253 be rendered unconstitutional, not the entire public health code.
Yes,
And the EPGA was also enacted to protect the lives of people, just as Mr. Fowler pointed out that 2253 is.
I got your argument. Why don't you make one more point and then respond to the issue about the future treatment of the case if we carry on.
Oh, yeah, well, that's fine, Your Honor. I would welcome a standard scheduling order. I understand that they're going to appeal it right away, but.
Oh, yeah, I forgot. I forgot that all this goes right up. I'm new to that.
Yeah.
Okay.
Yeah, so.
Okay, so I won't fret about that right now. Very good. All right, I think I understand the case. I'm going to issue a written ruling, an opinion in order. And that's sufficient for me. If there's anything that either of you feels I missed and we must cover, now, let me know now, otherwise I'll conclude the hearing. Nope.
Judge, just
Okay.
want to thank you for your time and attention this morning. We really
Okay.
appreciate
Thank
it.
you both.
Yeah, thank
And
you, Your Honor.
I'm going to sign off, and I imagine the court reporter will want to know if either of you are ordered. Okay? Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
Do either of you need transcript?
Mr. Kelly,
I would love one, please.
Okay,
we'll purchase a copy then.
all right, thank you.
Thank
Thank
you.
you so much.